Welcome back to the Deep Dive. We are jumping into, a realm of law that maybe on the surface sounds like an instant cure for insomnia. Federal rules of civil procedure.
Yeah, I know. It doesn't exactly scream excitement.
But stick with us, because the core question here is actually pretty high stakes for really anyone involved in a lawsuit.
Yeah.
Can the court system give you a do-over if you make a massive administrative blunder and accidentally kill your own case?
It's kind of the ultimate procedural lifeline, isn't it? Our deep dive today is focused entirely on this unanimous Supreme Court decision from earlier this year, Waetzig v. Halliburton Energy Services, Inc.
Right.
And this ruling, it settles a really fundamental disagreement among lower courts about, well, procedural fairness.
Okay, let's unpack this then. We're trying to define the boundaries of Federal Rule of Civil Procedure 60B.
You called it a safety net.
Exactly. It's designed to offer relief from a final judgment, order, or proceeding. And for the last few years, courts have been split on whether just, voluntarily dropping your own lawsuit counts as one of those final proceedings. Gotcha. So our mission here is to explain why the Supreme Court decided that, yes, it absolutely does count.
And this really matters because, think about it, if you make a mistake, you drop your case, and maybe the statute of limitations runs out. Without Rule 60B, your claim could be dead, like forever dead. The court system would have no power to help you.
Okay, so let's start with the specifics. The facts of the case, the mistake itself. We have Gary Waetzig. He filed an age discrimination lawsuit against his former employer, Halliburton Energy Services.
Right, and Halliburton immediately moved to force the claim into mandatory arbitration. Standard playbook sometimes.
And this is where things got tricky for Waetzig, procedurally speaking.
This is the critical juncture, yeah. He had a clear, much safer route available. He could have asked the district court to stay the federal lawsuit, basically hit the pause button until arbitration was done.
And that's allowed.
Oh yeah, it's explicitly permitted under the law. 9 U.S.C. Section 3 is pretty standard.
But Waetzig took a different path. Instead of asking for a pause, he voluntarily dismissed the entire case under Rule 41A.
That's the one. And the key here, as you mentioned earlier, is that this dismissal was filed without prejudice.
Explain that again, without prejudice.
Okay, so when a plaintiff dismisses a case without prejudice, the lawsuit is formally terminated, it's off the court's docket, but critically, the plaintiff keeps the right to refile those same claims later. And because Halliburton hadn't yet filed a formal answer or moved for summary judgment, Waetzig's dismissal was effective immediately. Just by filing the notice, no judge needed to sign off, poof, case gone.
Okay, so the federal case is terminated. Waetzig goes off to arbitration.
Yeah.
And he loses.
Right, he loses. And he thinks the arbitrator made procedural errors, so he wants a federal judge to review it.
Makes sense. But how does he get back into federal court if he already dismissed the case?
Precisely the problem. Because the underlying federal case had been terminated, the clock for challenging that arbitration award was ticking down fast. He realized he probably couldn't file a new case to challenge the arbitration because the deadline, the statute of limitations, had likely passed.
Oof. So he's kind of stuck, which brings us to his, creative solution.
Very creative. He went back to the old, already dismissed federal lawsuit, found the original docket number, and filed a motion asking the court to reopen that case.
Under what grounds? How can you just reopen a closed case?
He was basically throwing himself on the mercy of the court using Rule 60B1. His argument was, look, I made a mistake, maybe inadvertence or excusable neglect, by dismissing the case when I really should have just paused it. I am asking you to grant relief from that error and put the case back on the docket.
And the district court? They bought it.
Initially, yes. The district court agreed. They found Waetzig made a careless mistake and granted him relief under Rule 60B1. They reopened the case.
Okay, seems like procedural mercy in action. But then...
And then the 10th Circuit Court of Appeals stepped in and reversed it. They disagreed vehemently.
Why? If 60B is designed for mistakes, wasn't the district court just doing its job?
It sounds reasonable, doesn't it? But the 10th Circuit said basically, no way. They argued that a simple voluntary dismissal, just a piece of paper filed by the plaintiff, isn't final enough to qualify under Rule 60B.
What do they mean by final enough?
They argued that the phrase final judgment, order, or proceeding implies some kind of substantive judicial determination, like a judge had to be involved in the termination.
Yeah.
Since Waetzig just filed a notice and the court didn't actively do anything, the 10th Circuit said it couldn't be reopened using this rule.
Okay, so that sets up the central legal showdown for the Supreme Court.
Yeah.
Did Waetzig's voluntary termination of his own case count as a final judgment, order, or proceeding, giving the court the power under 60B to undo that dismissal?
Exactly. And what's fascinating here is that the lower courts were genuinely split. The 10th Circuit said, no, definitely not. But other circuits, like the 5th and 7th, had previously said, yes, these voluntary dismissals do count. So you had a real circuit split, a disagreement that needed resolving.
A classic reason for the Supreme Court to step in. So how did they tackle it? How did they define final?
Well, they did what courts often do. They went back to the basics, the language of the rule. They looked at dictionary definitions, specifically from 1946.
Why 1946?
Because that's the year the word final was actually added to Rule 60B, so they wanted to know what final meant back then. And the dictionary said it meant things like terminating, completed, conclusive, last.
That seems pretty straightforward.
Right.
If you voluntarily dismiss your case, that action absolutely terminates the case, right? It's the last step for that specific lawsuit on the docket.
That's exactly what the Supreme Court concluded. It fits the definition perfectly. The court emphasized that finality in the context of Rule 60B is really just used to distinguish cases that are completely over from interlocutory orders. Those are rulings made while a case is still ongoing.
So once the case is fully terminated, the court loses its inherent power to just change things willy-nilly.
Right. And that's when Rule 60B potentially kicks in as the only available lifeline if there was a mistake or some other valid reason.
Okay, but Halliburton pushed back on this, didn't they? They wanted a much stricter definition of finality.
They did. They tried to argue the court should use the definition of final that's used for deciding when you can appeal a case, like under the Appellate Jurisdiction Statute, 28 U.S.C. Section 1291.
And why is that definition different?
Well, finality for appeals is designed to prevent constant interruptions. You can generally only appeal when the whole case is truly final in the lower court, preventing piecemeal appeals of every little ruling. It's about judicial efficiency during the litigation process.
But relief under Rule 60B is different. It happens after the case is over.
Entirely different. That was the court's point. A 60B motion only comes up after termination. And crucially, granting relief is entirely discretionary. The judge can just say no if they think the party doesn't deserve it or is gaming the system.
I see. So the risk of constant interruption isn't there in the same way?
Exactly. So the court said using that strict appellate definition here would be inappropriate. It doesn't fit the purpose of Rule 60B, which is about offering discretionary relief from potentially unfair terminations.
Okay, so the dismissal is final because it terminates the action. Simple enough. But what about the second sticking point? The word proceeding. This seems to be where the 10th Circuit's argument about needing a judicial action was strongest.
Yes, this was a key part of Halliburton's argument too. They pointed to the phrase judgment, order, or proceeding and said, look, judgment involves a judge, order involves a judge, so proceeding must also involve some kind of judicial action to fit in. It's a textual argument based on context.
Makes intuitive sense, like terms should be interpreted similarly.
It does, but the Supreme Court found a structural flaw in that logic. They argued that if proceeding also required a judicial determination, it would basically just mean the same thing as order. Any judicial determination that terminates a case but isn't a final judgment is essentially an order.
So proceeding would become redundant. It wouldn't add anything.
Precisely. It would strip proceeding of any independent meaning. So the court looked at dictionary definitions of proceeding itself, finding it's defined really broadly, covering all possible steps in an action, including formal steps taken in conducting litigation or things simply noted on the docket.
Okay.
And then they highlighted what they called the ascending order of generality within Rule 60B's phrase.
Ascending order of generality. Okay, walk us through that. Sounds important.
It's the core of their textual analysis here. They said the rule is structured to go from the narrowest term to the broadest. Judgment is the narrowest, the formal final decision. Order is broader, covers lots of judicial rulings, final or not. Therefore, proceeding must be the broadest category.
The catch-all.
Exactly, the catch-all. It encompasses everything else, including formal steps that terminate the action, even if a judge didn't explicitly sign off on that specific step. A voluntary dismissal, which is a formal notice filed on the docket that terminates the case. Well, it fits perfectly into that broadest category, proceeding.
So the court is essentially saying proceeding acts like, I don't know, the miscellaneous file. It ensures that any formal action that definitively ends a case falls under the potential scope of Rule 60B's safety net.
That's a good way to put it. And they bolstered this reading with history. They pointed out that Rule 60B was modeled on an older California statute, and that California statute had already been interpreted by courts to apply to voluntary dismissals, regardless of whether they were with or without prejudice.
Ah, so history backed up the broad interpretation too.
It did. It suggested the drafters likely intended this broader scope, contrary to the 10th Circuit's narrow review.
Okay, so this brings us to the bottom line, the final word from the court. What was the ultimate conclusion, and was it the immediate impact for, people listening?
The Supreme Court unanimously ruled that yes, a Rule 41A, voluntary dismissal without prejudice, does count as a final proceeding under Rule 60B.
Unanimous, wow.
Yeah, that's significant. It means the district court does have the power to reopen such a case if the party meets the requirements for relief, like proving mistake, inadvertence, or excusable neglect, which is still a high bar, mind you.
So it confirms this mechanism for procedural mercy exists even for these self-inflicted dismissals.
Correct. It provides that safety valve.
This seems huge then, for any individual or business, frankly, facing litigation. If your lawyer, say, makes a procedural foot fault and dismisses a claim when they meant to just pause it, that error isn't automatically fatal anymore. It can potentially be fixed.
Potentially, yes. That's the key word. Because, and this is really important, the court only decided the question of power. They said the district court has the authority under Rule 60B, but they explicitly expressed no view on whether reopening the case was actually the right decision in Waetzig's specific situation. Was his mistake truly excusable neglect worthy of relief? That question goes back to the lower courts. Okay. So, even though Waetzig won this battle at the Supreme Court on the meaning of the rule, he might still lose the war on whether his particular mistake justifies using the rule.
Exactly. The bar for proving excusable neglect can be quite high, and there's an even bigger unresolved issue.
Oh, what's that?
The elephant in the room, really. The Supreme Court completely sidestepped the jurisdictional question. Meaning, they explicitly did not decide whether the district court, even if it properly reopened the case, actually had the statutory power, the jurisdiction, to then review and potentially vacate the underlying arbitration award.
Why wouldn't it have that power?
Well, federal court review of arbitration awards is strictly limited by statute and some pretty complex case law, like the Badgerow and Kokkonen cases they mentioned. It's not automatic. Just because you reopen the old case doesn't necessarily mean the court suddenly gains power to meddle with the arbitration outcome that happened outside of that case. So they opened the door for him to potentially fix the dismissal mistake, but left completely unanswered whether opening that door actually lets him challenge the arbitration loss in federal court.
You got it. By ducking that jurisdictional question, the court ensured that while the procedural path is clearer, the ultimate goal for Waetzig getting federal review of his arbitration loss remains very much up in the air.
Okay, so let's try to summarize the key takeaways for everyone listening. The big one is a technical procedural mistake, like voluntarily dismissing your lawsuit when you maybe shouldn't have, can now potentially be undone using Rule 60B.
Right. The court gave a broad, generous reading to final proceeding to allow for that possibility. That door is confirmed open.
The ability to reopen is confirmed based on that expansive meaning.
Absolutely. The procedural door to undo that kind of filing mistake is now clearly open. But, and this is maybe the final thought to leave folks with, this deep dive really just sets the stage for the next procedural battle. While the Supreme Court confirmed the power to undo the dismissal, that core jurisdiction issue, whether the federal court, once the case is revived, can even touch the underlying arbitration decision, that remains completely unresolved. It's a critical reminder that even when one procedural door opens, figuring out who actually gets to decide the substance of the dispute, well, that's often the next, and sometimes much bigger, legal hurdle. This case fixed one problem, but highlighted another huge one waiting down the line.